Hello, this is Tim Summelroth, and I'm going to talk to you today about objections. Now, in order to be able to be a good mock trial lawyer or even a mock trial witness, you have to have some understanding of the rules of evidence and how they affect a witness's testimony. So the easiest way to think about the objections that are allowed under mock trial rules is to think of objections in two categories. Number one, I want you to think of objections in terms of substantive objections. And so those are objections that are being made to the substance of what the witness is testifying about. So it's not the way that they've been asked the question, it is about the actual subject of what they're being asked about. Those are substantive objections. And then the second kind of objections are procedural objections. And those objections come into play when somebody is not following the rules and they're asking a question wrong. And so I want to focus early in the mock trial season on substantive objections, because one thing that I always recommend both lawyers and witnesses do is that whatever witness that you're doing a part for, either you're direct examining a witness, you're cross-examining a witness, or you're playing that witness, you have that witness statement. And it is helpful to go through that witness statement early before you start writing out full directs and crosses, and highlight all of the things that are substantively objectionable, so that you keep that in mind when you decide what questions you're going to ask, or when you're a witness, what testimony you're going to give. So let's start with substantive. The first substantive objection I want to talk about is hearsay. Now, the definition of hearsay is that it is an out-of-court statement being used to prove the truth of what is being asserted. So in other words, it is when somebody is testifying about hearing somebody else say something, not in the courtroom, but wherever they were otherwise. They hear somebody saying it, and you're trying to have that witness talk about what they heard, because you're trying to prove that what they heard is true. And so that's what it means. It's got to be an out-of-court statement, so something that somebody said out of court, and it is something that is being offered to prove the truth of what the statement was. So there are a number of exceptions to what constitutes hearsay, but a good initial step early on in the case is to read through your witness statement and highlight whenever somebody is testifying about what somebody said outside of the courtroom. Just know that that is likely to be objected to as hearsay, and then you can talk to your coaches about whether or not there is a hearsay exception that applies. The second type of substantive objection is the objection of speculation. Now, witnesses are allowed to testify about things that they personally observe, things that they saw, sometimes things that they heard, though, as we've just talked about, sometimes that can be objected to as hearsay. Now, if a witness is testifying about something that they didn't see, or they're guessing about what somebody was thinking when they saw that person do something, then they're speculating, they're guessing. And so in the witness statements, you will often see speculation testimony. You'll see a witness who is guessing about why somebody did something or what they were thinking when they did something. And unless a witness has some expertise, some education, training, or experience that allows them to guess, then that testimony is objectionable and it shouldn't be allowed into evidence because it's speculation. So you want to make sure that you take time to identify any speculation in a witness statement that you're responsible for. The third substantive type of objection is the improper opinion objection. And so there are, again, that gets back to the idea that a witness is only supposed to be able to testify about things that they have observed, things that they've seen, things that they've heard. And if they haven't seen it, or if they haven't heard it, then they're offering an opinion. They're guessing about something. And so if a witness is guessing about something that they didn't see or they didn't hear, then that you would argue that that's an improper opinion. So that is the most common type of improper opinion. Another type of improper opinion is if a witness who has one specialty testifies, offers an opinion about another specialty. So for example, if I'm a medical doctor, I can give medical opinions once foundation's been laid about my expertise. But if I start giving an opinion about a mechanical issue, then that would be an improper expert opinion, unless there's been evidence laid that I am an expert in mechanics as well as being an expert in medicine. So you want to take a look in your witness statements and see if there is an opinion being offered by the witness that is, it's an improper opinion because it's not based upon their perceptions, or if it's an improper opinion because the witness doesn't have the expertise to offer that kind of technical or expert opinion. The next type of substantive evidence or substantive objection is relevance. And this is something that we talked about when we talked about the law of the case, that there are certain things that the plaintiff has to prove, or there are certain elements that the defense has to prove. And technically, in order for any evidence to be allowed in during a trial, it has to be probative, or it has to go to the existence of a fact that is helpful in determining one of the jury questions that has to be answered in that case. So if you can't figure out why a particular fact would be important to being able to answer the questions of negligence or the questions of causation, then you have to ask yourself, is it really relevant at all? So the technical definition is, evidence is relevant if it has any tendency to make the existence of any fact of consequence to the determination of the action more probable or less probable. So all that means is, does it go to one of the jury questions? Does it either prove or disprove one of the jury questions in your case? And if it doesn't, you would be making the objection that it's not relevant. Now, there is an issue that is always relevant, and that is the issue of the credibility of a witness. And so if there is evidence that suggests that a witness should not be believed, then that is always relevant, regardless if it goes to a particular issue in the case. The next substantive objection is improper character evidence. So character evidence has to do with a person's prior behavior, a person's behavior before whatever the events are of this case. And in general, the law says that you're not allowed to offer up evidence of a person's prior bad acts in order to try to prove that they were likely doing something bad in this particular case. So for example, if I am charged with speeding, the law says that typically you can't offer other situations where I was speeding in order to try to prove that I was speeding in this particular case. In other words, that the burden of proving me speeding has to be based upon evidence of this particular event. You can't bring up past history. And so you have to look and see, are they trying to bring up prior bad acts of a particular witness or person in the case? And if so, you need to think about, well, why are they trying to offer that into evidence? And if they're trying to offer it into evidence to show that because he did something like this in the past, he probably did it in this case, then that would be improper character evidence. And so you want to read through your witness statements and see if there's any examples of improper character evidence that that you need to object to or be prepared to argue why it's admissible. So those were the examples of the substantive objections that are allowed in mock trial. And like I said, the best thing you can do with that information is to go through your witness statement and just go category by category and say, do I have any hearsay in this witness statement? Okay, have I highlighted that? Do I have any speculation in this witness statement? Okay, I got to make sure I highlight that. So you just need to go through and do that for each of the substantive objections. Now this next category, procedural evidence. Procedural evidence or procedural objections, you can't prepare in advance to do those because they really only come up if the question gets asked in a particular way during your trial. So lawyers are the ones who really need to understand procedural objections. You need to be able to write questions that aren't going to draw a procedural objection. And then you need to listen carefully, because if there is a procedural objection, when you hear it, you got to object at that time. So the different procedural objections that I'm going to be talking about, let's start with lack of foundation. So lack of foundation is an objection that you make when the other side has not offered the testimony or evidence that allows somebody to say what they're going to say next. So for example, if I am an expert in fire inspection and I want to offer an opinion about why a fire started, before you can offer that opinion, you have to have explained your expertise, your training, your experience, your education. And so if a witness got asked about an expert opinion before that sort of background evidence has been offered, that would be something that you would object to as lack of foundation, because the rule is that all exhibits and opinions must have the necessary foundations in the record before you can admit the evidence that requires those background. All right, the next procedural objection is asked and answered. What this means is that if a witness has already been asked a question once by a particular lawyer, they're not supposed to be asked the exact same question again. So if I'm doing a direct examination and I ask the witness a question, and then they get cross-examined, and when it's my turn to do redirect, I can't just ask the exact same question I asked before, or the other side will object to asked and answered. The more common occurrence is when you're doing a cross-examination and you ask the witness the exact same question that you asked them before. So keep in mind, it only applies to the questioner can't ask the exact same question again if they've already gotten an answer. If a question is asked on direct examination, the cross-examiner could still ask the same question if they wanted to. Or if a question's been asked on cross, the direct examiner can still ask the question again. Now we could get into whether or not that's a good idea to just repeat a question that's already been asked. But the point is that one lawyer is not allowed to ask the same question that's he or she's already gotten an answer to again during the testimony of that witness. All right, the next objection is leading. And leading means that the lawyer is asking the witness a question in such a way that it is suggesting, the lawyer is suggesting how the question should be answered. So an example would be, you go to Regis, don't you? I'm basically telling you what I want you to say. That's a leading question. Now, leading questions are not allowed during direct examination. You should object to a leading question during direct examination. But leading questions are allowed during cross-examination. So, in fact, most cross-examination questions should be leading. So when you are on direct, you need to be careful that you're not asking leading questions. And if you are on cross and you hear a direct examining attorney ask a leading question, then you should object to it as leading. The last procedural objection I want to talk to you about is argumentative, or badgering the witness. And basically what this means is you're not really trying to get an answer to a question. You're just trying to argue with the witness. You're just trying to convince them of something, or you're not actually trying to get an answer. You're just making a comment. And so as long as you're asking good leading questions on cross-examination, it shouldn't come up. This isn't an objection that is usually very appropriate. In fact, we don't recommend that Regis mock trial teams typically make the argumentative or badgering objection. So why are we talking about it? Because somebody, when you're on cross-examination, somebody may object to one of your questions as argumentative or badgering, and your response should be, Your Honor, I'm not being argumentative. I really want to get the witness's answer to this question. It's an appropriate question. So those are the basic objections that are allowed under mock trial rules. And so hopefully that helps you. Now there are a lot of exceptions or nuances to evidentiary issues, and those are things that you should definitely ask questions about with your coaches. But the best thing that lawyers or witnesses can do is to identify the substantive objections that could come up in the witness statement and know what those are and have a plan for how you're going to deal with them if that sort of testimony were to come up in your case. So thank you very much, and I'll be back with some more mock trial soon.